Good morning, and welcome to the Professional Group Plans webinar series, Common Questions, Practical Answers. My name is Kim Wilcoxon. I'm an attorney at Thompson Hine, and Professional Group Plans has partnered with us to provide a series of very short webinars to help address common questions that may be experienced by brokers who are working with employers seeking to provide health insurance coverage to their employees. We will be conducting these webinars on the first Tuesday of each month for the next few months, and they're intended to be sort of short, not less than 15 minutes, not more than 30 minutes, but just short bites to give you a general overview of some of these common issues. They won't provide all the detail that you may need to know in order to answer a particular question, but should be able to give you a sense of the general rules and let you know when you need to ask for more information. So to start off this month, we're going to be talking about situations where employers want to treat employees differently. And as soon as I get there, we go. First, we're going to go through a number of examples of where employers try to treat employees differently, so we know what we're addressing today. Then we're going to have 4 questions that we're going to ask you to consider each time you want to know whether it's okay for an employer to treat employees differently. In response to those questions, we're going to talk about the Cafeteria Plan non-discrimination issues, Code Section 105H non-discrimination issues, discrimination on the basis of a health factor, and insurance requirements. If you have questions at any point in the presentation, please go ahead and type them into the chat box, or not the chat box, but the question box. I can't guarantee that we'll have time to address them all, but we'll do our best as we go along. And because I'm an attorney, I have to give you this disclaimer that this presentation is not intended as legal advice or a comprehensive review of all legal requirements. Brokers and PGP folks should not try to attempt to provide legal advice to employers, and employers should consult legal counsel to confirm the obligations applicable to their business. That being said, what do we mean when we talk about treating employees differently? Well, an employer might want to have different eligibility requirements. So, for example, only a select group of employees is eligible to participate in the medical plan. Or maybe full-time employees are eligible to participate in the benefits, part-time employees are not. When we talk about different waiting periods, well, different groups of employees may have different waiting periods. So a full-time employee may have get into the medical plan after 30 days of employment, whereas part-time employees can get into the medical plan after 90 days of employment. There may be different benefits that an employer wants to provide. So for example, maybe there are 3 insurance plan options available to full-time employees, but only 1 available to part-time employees. Or in merger and acquisition situations, let's say company A acquires company B. They maintained separate health plans before the acquisition. Are they allowed to continue to maintain separate health plans even now that they're part of the same control group? And you may see different premiums. An employer may contribute more to the cost of coverage for a select group of employees. So for example, maybe the medical premium is $300 for salaried employees, but $500 for hourly employees. How do you know whether it's okay for an employer to treat employees differently in these aspects? Well, first you want to ask yourself, are premiums paid with pre-tax dollars? Then you'll ask, is the plan self-funded or fully insured? Then you'll want to ask whether the design is based on a health factor. And finally, you'll want to ask if the insurance company will provide the necessary coverage. So are premiums paid with pre-tax dollars? If so, then we have to worry about the Cafeteria Plan non-discrimination rules. These are rules that are included in Section 125 of the Internal Revenue Code. You may hear them referred to as Code Section 125 rules, Cafeteria Plan rules, Flexible Benefit Plan rules. In any event, when premiums are paid with pre-tax dollars, the Cafeteria Plan rules prohibit a plan from offering better or lower cost benefits to members of the prohibited group. Now, that doesn't mean that you can't treat members of the prohibited group better than people who are not in the prohibited group. And we'll talk in a minute about who's in the prohibited group and what this means. But generally, if an employer's plan violates the 125 non-discrimination rules, then contributions made under the plan by members of the prohibited group are considered taxable. So there's no adverse, there's no bad impact on employees who are not in the prohibited group. Folks that are in the prohibited group will have to pay their premiums on an after-tax basis. Or if they've already paid on a pre-tax basis, those payments have to be recharacterized as income to the employee. So what do I mean by prohibited groups? There are two different types of prohibited groups. One is called a highly compensated individual. Sometimes under the rules it's called a highly compensated participant. But for this purpose, a highly compensated individual is someone who owns more than 5% of the organization, an officer of the organization, an employee with compensation in excess of the prohibited specific amount, or a spouse or dependent of one of the above. And I just want to pause just a minute. A question came in, is this audio only or is there a slideshow? There is a slideshow. It should have been accessed through a link in the invitation you received. And there are slides. The slides themselves should be available through the link. I see that there may be some difficulty in downloading those. If you are not able to access the slides during the presentation, you can send an email to Elise Hoffer, whose email address was in the invitation, and we can make sure that you get a copy of the slides after the presentation. So back to the slides aren't showing. Okay, I see that slides aren't showing for anyone at this point in time. So we are working to correct that issue. In the meantime, I'll go ahead. The prohibited group, as I mentioned, there are two types of prohibited groups. One is a more than 5% owner, an officer, an employee with compensation in excess of a specific amount, or the spouse or dependent of one of the individuals that I just described. Another prohibited group is key employees, which would be an officer of compensation over a certain amount, an owner of more than 1% of the organization, and a more than 5% owner. And hopefully the slides are showing now. I think we got that taken care of. So hopefully you can see on this slide the details of the group. And I apologize for the technical difficulty there. So now that we know who our prohibited groups are, we've got the highly compensated folks, the officers, the owners. We need to run tests to determine whether benefits provided to them are violating the non-discrimination rule. I'm sorry, we are experiencing the technical difficulties again. So I apologize. We'll go ahead and keep talking. I swear this was working before we started. There are three types of tests that need to be considered when talking about the cafeteria plan rules. One is an eligibility test. Eligibility determines whether enough folks who are not in the prohibited group have been offered the coverage. Then there's the benefits and contributions test. So are the benefits provided to folks who are not in the prohibited group good enough in light of what we're offering to folks in the prohibited group? And then we have a key employee concentration test, which says that no more than 25% of the aggregate benefits provided to employees under the plan can be provided to key employees. I'm not going to go into detail on these test requirements because the test requirements are very complicated. They are provided through cafeteria plan rules that were proposed and then reproposed and have never been finalized. The IRS has gotten a number of comments on the proposed rules about how exactly they should apply. I'm not sure the IRS knows how they apply. I will say that lawyers and testing providers will take their best guess based on the information provided, but it is difficult to know whether the cafeteria plan rules truly have been satisfied. So if an employer is having their employees pay for premiums on a pre-tax basis, they should seek legal counsel about how to address the cafeteria plan rules. So again, it's not to say that if they're paying for premiums on a pre-tax basis, you can't treat groups differently. It's just that you would need to be able to satisfy these rules. There are vendors out there who will conduct the test based on our best understanding of the rules, and there's no good rule of thumb. I would say overall, if an employer is not intending to benefit the highly paid group, if they're intending to sort of make differences applicable across general business lines, then there's probably low risk. but an employer should consult with legal counsel before moving forward. So the next question is the plan self-funded or fully insured? If it's self-funded, we have another set of non-discrimination rules we have to consider, and those are under Code Section 105H. Now, the Affordable Care Act added similar non-discrimination rules for fully insured plans, but those rules haven't yet been written. So at this point in time, we don't have these additional rules that apply to fully insured plans. So if you're satisfying the cafeteria plan rules and the rest of the issues we're going to talk about today, then it should be fine. But if the plan is self-funded, we have this additional requirement to consider. However, if health coverage is paid 100% with after-tax dollars, or if the fair market value of the coverage is treated as taxable to the employee, then we don't have to worry about these rules as applied to those employees. Generally, the Code Section 105H non-discrimination rules prevent you from treating a highly compensated individual better than you treat a non-highly compensated individual. And if the plan violates the Code Section 105H rules, some or all of the benefits paid to the highly compensated individual would be considered taxable. Contrast this to the cafeteria plan rules where the contributions are taxable. Here, the benefits could be taxable. So for example, a highly compensated individual pays $300 a month for health insurance coverage. The individual goes to the hospital, has a procedure done. The plan pays $20,000 to the hospital for that procedure. Part or all of that $20,000 could be considered taxable income to the highly compensated individual if these rules aren't followed. So what does 105H require? Or I guess that we should first talk about who highly compensated individuals are, because it's different for purposes of this test than it is for purposes of the cafeteria plan test. So it's the same term, highly compensated individual, but it's determined in a different way. And so for purposes of the 105H test, we're actually looking at the top 5 highest paid officers, individuals who own more than 10% of the value of the company's stock, and the top 25% most highly paid employees. And we're looking at this on a controlled group basis. So if there are related companies, you would look at all of the employees together to determine your top 25%. Now, there are certain exclusions. For example, employees who are not in the plan who don't yet have a certain number of years of service or under a certain age or under a certain income level. But basically what you're looking at is the top 25% employees. So the Code Section 105H non-discrimination testing consists of 2 different tests. An eligibility test to make sure we've offered the plan to enough non-highly compensated individuals, and then a benefits test. And the benefits test is a hard one to pass because generally, if you're offering something to a highly compensated individual, you have to offer that same benefit to all non-highly compensated individuals. So for example, where we're looking at different benefits, if full-time employees are eligible for 3 different medical plan options and the part-time employees are eligible only for 1, chances are you've got highly compensated individuals who are full-time employees who are eligible for all 3, and chances are you've got non-highly compensated individuals who are part-time who are eligible only for the 1. That design would fail the 105H benefits test unless you take steps to readjust things. So again, the 105H rules, just like the cafeteria plan rules, are unclear. The IRS does not issue guidance on the 105H rules. So again, as much as I hate to say, consult with legal counsel because it sounds self-serving, with these rules, because they're uncertain, because they're gray, if an employer wants to treat employees differently with a self-funded plan, they really should be talking to legal counsel about how to address these rules. The third question you want to ask is the design based on a health factor? Because even if we satisfy the cafeteria plan rules, and even if we satisfy the Code Section 105H rules, if we're discriminating against someone on the basis of a health factor, then we've got a problem. Generally, it's okay to split people on similarly situated lines. So for example, we could treat different job categories the same without violating this health plan discrimination rule. We could treat salaried one way, hourly one way. We could treat employees differently based on whether they're in Ohio or New York or Connecticut. We can treat different businesses differently because none of those should be based on a health factor. If we do design a plan that discriminates on the basis of a health factor, then the violation creates an obligation to pay a self-reportable excise tax. It's generally equal to $100 per affected individual per day until the violation is corrected. And so depending on how many folks you have in the plan and how long this goes on, this could be a significant penalty for an employer. Now let's look at an example of something that may not look like discrimination on its face, but really is discrimination in intent. So let's say a hospital group has two locations, Hospital 1 and Hospital 2. Let's say Hospital 1 offers a richer health plan than Hospital 2. And let's say a nurse is hired, and that nurse has a medical condition, and the hospital knows that the nurse has a medical condition. And the hospital could place the nurse at Hospital 1 or Hospital 2, and the hospital decides to place the nurse at Hospital 2 so that the nurse won't generate too many costs under the richer health plan. So there's more cost sharing. It's going to benefit the hospital financially to have that sicker individual in the lower cost plan. Well, that situation presents significant risk. Even though the design is based on what looks like similarly situated groups, employees at Hospital 1 and employees at Hospital 2, the employer has chosen to put someone in Hospital 2 because of the health factor, and that creates risk, and the employer should consult with legal counsel in that case. And last but not least, you want to ask yourself, is the insurance company actually going to provide the coverage? Because if an employer promises benefits that an insurance company doesn't provide, the employer is going to be on the hook for those benefits. So if the employer is offering a fully insured health plan, the employer will need to make sure that the insurance company will cover the benefits that have been promised in the design that the employer has established. If the employer offers a self-funded health plan, the employer clearly has more discretion over design, but may have stop-loss insurance. And so if the employer is making changes mid-year, or the stop-loss insurer may have certain requirements, the employer should be aware of those as well. And the employer should know if there are any minimum coverage requirements or required contribution schemes that the insurance company is going to require, because if the employer then doesn't meet that, then the insurance policy could be terminated. So to recap, whether an employer can treat employees differently for purposes of the medical plan depends on facts and circumstances. It's not an easy yes or no. A wrong decision could impact taxation of contributions and or benefits. And decisions motivated by health factors present significant risk to the employer. And finally, insurance requirements should be consulted. That brings us to the end of the prepared presentation. If anyone has any questions at this time, you're welcome to submit them. Otherwise, you can tune in next month, and we'll talk about another topic with some common questions and practical answers. Seeing no questions come in, we'll go ahead and disconnect. Thank you very much.